The U.S. Supreme Court is hearing arguments on whether to allow President Donald Trump's executive order ending birthright citizenship in the United States to go into effect. Political anchor Curtis Jackson sat down with a professor of law to break down the arguments.
Does the president have the power to force courts to alter the meaning of the Constitution with just a stroke of his Sharpie? That question was at the heart of the Supreme Court hearing over his birthright citizenship executive order. Professor Paul Finkelman of the University of Toledo School of Law joins me now. Professor Finkelman, always good to see you. I want to start here. The Trump administration did not even attempt to argue the meaning of birthright citizenship, at least not fully. Instead, it just focused on whether lower federal courts can issue nationwide stays of the president's executive orders. All the justices did seem to agree that judge shopping or finding a court that will agree to issue a universal injunction is a problem, but there's a lot more at stake here. Is one issue tied to the other, or can the court reject the president's interpretation of birthright citizenship while ruling against universal injunctions?
Well, the court could do what it wants, but I seriously doubt that the court would in fact say that his interpretation of birthright citizenship is wrong without having full argumentation in a separate hearing. And that's the problem that's facing us right now, because if these injunctions are struck down, then presumably the federal government could refuse to issue Social Security numbers and any other federal paperwork to anyone born in a jurisdiction where a U.S. district judge has not declared a stay on it. So you could have, for example, thousands of children born in one state or one city who are not entitled to a Social Security number because no judge has issued a stay. And if they move to another state where where the stay has been granted, they would have no documentation that they are in fact born as U.S. citizens, because the 14th Amendment says all persons born in the United States are citizens at birth.
The plaintiffs, of course, calling that administrative upheaval. The meaning of birthright citizenship, though, did not go unmentioned. It was referred to as, quote unquote, the merits of the case. One of the reasons that plaintiffs say the court should reject the EO is because the administration is wrong on the law, and that will ultimately be proven before the court should it take up the interpretation of birthright citizenship. It was a point that the Solicitor General fought right up to the very end. Take a listen.
The original meaning of the citizenship clause extended citizenship to the children of former slaves, not to people who are unlawfully or temporarily present in the United States.
Right in your will, well, Professor, you've got less than a minute for rebuttal.
Well, he's simply factually wrong. He doesn't know what he's talking about. In Congress, when they're debating the 14th Amendment, one of the senators from Pennsylvania asks, does this mean that children of Chinese, and then he used what is today a very offensive word for the Roma people, gypsies, he says, will the children of these people be citizens of the United States? And Lyman Trumbull, the author of the 13th Amendment, a longtime friend of the late President Lincoln, said, undoubtedly. Everyone in Congress knows that this is more than is about the children of former slaves. This is about anyone born in the United States.
Paul Finkelman, professor of law at the University of Toledo. Professor, thank you.